So what's a fraudulent conveyance? The bankruptcy fraudulent conveyance laws are set out in section 548 of the Bankruptcy Code. Unfortunately, this section of the Bankruptcy Code is rather obtuse. It's very difficult to understand and follow. Also, most of the law with respect to this section has been fleshed out considerably by judges in the form of case law opinions. What I'm going to try to do is risk oversimplifying these very, very complicated laws, at least to make them more understandable. Basic concept. While fraudulent conveyance cases can get very complicated, the basic concept of a fraudulent conveyance is pretty simple and makes perfect sense. The basic concept is that a debtor, either an individual or a company, transferred assets to a third party, not the creditors, prior to a bankruptcy, for less than what those assets were worth when the debtor was insolvent. A couple of terms. By debtor, I just made a company or person that owes money. By insolvent, to keep things simple, I'm only referring to balance sheet insolvency. In other words, the company or individual owes more than its assets. So what's the problem? Who cares that an insolvent debtor transferred property before going bankrupt? After bankruptcy is filed, a bankruptcy trustee will need to divide up assets to pay creditors. If the assets the creditor gave away, if those assets are given to third parties before the bankruptcy filing, there's not going to be anything to divide up. Nothing to distribute, or at least much less to distribute. Creditors are hurt. It's all about creditors. It's protecting people that lend money or are owed money and make sure they're not harmed. The fraudulent conveyance laws are meant to protect, again, creditors so that the trustee can pay them what they are owed, or at least try to pay them a portion of what they're owed. If a debtor hides or gives away assets that can be sold to pay creditors before bankruptcy, it's not very fair to the folks that are owed money. The purpose of the fraudulent conveyance laws is to bring back assets and money that somehow disappeared and make things right for people that are owed money. It's a lot easier if I throw out a couple of hypotheticals rather than talk in abstractions. Consider hypothetical number one. Mr. Jones owes $100,000 to Mr. Green. Mr. Jones has exactly $100,000 in assets. Mr. Green threatens Mr. Jones with a lawsuit since the debt has been unpaid. Instead of paying Mr. Green, Mr. Jones transfers his assets, transfers the $100,000 to his friend, Mr. Smith, who temporarily holds the money until Mr. Jones can come back and get his assets safely. Mr. Jones files for bankruptcy to discharge the debt owed to Mr. Green, to get Mr. Green off his back, or fool Mr. Green. A trustee is appointed, and of course, there are no assets to distribute to Mr. Green. The trustee finds out about the transfer and sues Mr. Smith for a fraudulent conveyance to recover the money back into the estate. The trustee recovers the money, and Mr. Green is paid by the bankruptcy estate, so everybody is happy except maybe Mr. Jones. This heartwarming story is a prototypical actual fraudulent conveyance case. I will explain what that is shortly. Hypothetical number two. In this hypothetical, Acme Industries makes a charitable donation of $100,000 to the Museum of Modern Art. Unfortunately, at the time Acme made the donation, it was insolvent. Acme files for bankruptcy a day later. A bankruptcy trustee finds out about the donation and sues the museum to recoup the money. Both Acme and the museum were acting in good faith. Unfortunately, the trustee will probably succeed since the company was insolvent and since Acme did really not get anything back for its donation. The assets left to pay creditors was reduced by $100,000 with nothing to show. So it simply is not fair to let the gift stand. The assets of the company were reduced by $100,000. It's not fair to creditors who have their distribution reduced, or have the pie is reduced by $100,000. It's simply not fair to permit the company to make donations when it doesn't have enough money to pay all its creditors. You might argue, well, it's unfair to the museum since they didn't do anything wrong. The answer is that's too bad. That's life in the big city. Congress has determined that it's more unfair for debtors to give away money when they can't pay their own creditors than it is to claw back the money from innocent recipients. After all, the museum is not really losing anything, since arguably the donation should not have been made in the first place. Actual versus constructive. As you can see from the above examples, there are two kinds of fraudulent conveyance lawsuits. The first is called an actual fraudulent conveyance lawsuit. The second is called a constructive fraudulent conveyance lawsuit. The bankruptcy trustee needs to prove different things to win an actual fraudulent conveyance lawsuit versus a constructive fraudulent conveyance lawsuit. Also, the defenses are different. In an actual fraudulent conveyance lawsuit, the trustee must prove that the debtor acted in bad faith. The trustee is permitted to use circumstantial evidence in the form of various indications of fraud. These are called badges of fraud. An example of a badge of fraud is that the transfer took place in secret. This implies an intent to hide the transaction. There are 12 badges of fraud. The trustee does not need to prove all of them, but of course, he will try to prove as many as possible. To prove an actual fraudulent conveyance, the trustee does not need to prove that the debtor was insolvent at the time of the transfer. Insolvency is not required. Actual fraudulent conveyance under the bankruptcy laws is a civil and not a criminal action, but it may involve an implication of intentional wrongdoing. Some states have criminal law counterparts. A defendant defends an actual fraudulent conveyance by proving it acted in good faith and that it transferred reasonably equivalent value in exchange for the alleged fraudulent transfers. Also, it disproves that there are any badges of fraud that could apply. The translation: I was not part of this. If this was a scam, I was not part of it. I knew nothing about it, and no creditors were hurt. Because the estate, the debtor, received reasonably equivalent value. So no creditors were hurt. There was no diminution of the assets of the estate. A constructive fraudulent conveyance does not involve allegations of fraud or wrongdoing or any implication of that. It's basically an allegation that the debtor just got less than its money's worth at the time it was insolvent. Creditors are being hurt because the assets to pay creditors are gone or worth a lot less. So it's not fair to the folks who are lending money or who owe money, trade creditors. The trustee in this situation needs to prove simply that the debtor did not get its money's worth and that the debtor was insolvent at the time. The defendant needs to prove it acted in good faith and it transferred reasonably equivalent value. It can also mount a defense by proving that the debtor was not insolvent at the time of the transfer. It's important to understand why the trustee needs to prove insolvency in the context of a constructive fraudulent conveyance case. If the debtor had been solvent at the time of the transfer and able to pay all creditors in full, then the fact that the debtor did not get reasonably equivalent value or even gave away money or assets results in no harm to anybody. Who cares if the debtor wants to donate a Picasso? The creditors would have gotten paid anyway. They're not going to be hurt if the debtor is solvent. Both actual fraudulent conveyance and constructive fraudulent conveyance laws are designed to protect creditors. If creditors are going to be paid in full, then there might be little reason to claw back money from anybody, especially if no fraud is involved. In my practice, I found that there are about 10 different types of fact patterns of fraudulent conveyance lawsuits. These are just my categories. You're not going to see this anywhere. But to give you a feel of what a fraudulent conveyance lawsuit is, I'm going to quickly go through each of these fact patterns. The first fact pattern I'm going to call parking assets. This is basically the first hypothetical I talked about where the debtor was insolvent and asked a friend or family member to hold on to assets temporarily and basically hide them from creditors. This is a very common form of fraudulent conveyance. This is typically an actual fraudulent conveyance case since there are badges of fraud involved and it just smells like there's intentional misrepresentation going on. A second category of fraudulent conveyance are gifts and charitable contributions. I also gave an example of this kind of fact pattern. Giving assets away is fine. It's great. It's noble, unless you're insolvent and you owe more to creditors than you can possibly pay, and then file a bankruptcy. Then it's not so good. You're essentially giving away somebody else's money, since creditors are not going to get paid in full. This is typically a constructive fraudulent conveyance type lawsuit since there is usually no fraudulent intent on either side of the transaction. Another kind of fraudulent conveyance I call sweetheart deals. In this situation, a debtor sells assets way below market value to a friend or a relative. This can be either an actual fraudulent conveyance or it could be a constructive fraudulent conveyance if there's no implication of any fraud or misrepresentation. The big issue in these types of cases is typically valuation and whether the recipient got a reasonably good deal or such a good deal that it would just be more fair to creditors to unwind the transaction. Was it a reasonably good deal or was it outrageous? The next category of fraudulent conveyance cases are Ponzi schemes. Ponzi schemes, like the Bernie Madoff scheme, often results in heartbreaking fraudulent conveyance clawback lawsuits. For example, you invest $100,000 with Bernie Madoff. Madoff pays you $25,000 in, quote, profits. It may be hard to show that you gave reasonably equivalent value in exchange for fake profits, profits that really didn't exist. Since there were no real profits and that money came from somebody else, the next person that Bernie defrauded, it's an actual fraudulent conveyance. Since the fraudulent enterprise obviously did not actually earn a profit, so there was really nothing to give. The debtor basically gave you money that was stolen from a third party. It may also be difficult to show good faith if the defendant had reason to know that it was a Ponzi scheme and tried to get out before other people. This kind of scenario was played out quite a few times in the Madoff case. A lot of Madoff victims not only saw their fake profits all of a sudden disappear, but they were sued and had to return this money that was paid to them that were fake profits, which may have been spent or invested in other investments that were hard to liquidate. Another category of fraudulent conveyance I'm going to call Piggy Banks. In this type of fraudulent conveyance, the owner or manager of a business will pay personal expenses to third parties from a company account when the business is insolvent and unable to pay all creditors in full. For example, I own a small business and I use a company credit card to buy gifts for my girlfriend. Actually, this is not an uncommon situation. Here, the trustee will sue the girlfriend to recover the funds. The girlfriend might argue that she gave reasonably equivalent value. Since this is a G-rated video, I'm not going to go into more details of this defense. Besides the girlfriend situation, which is actually a lot more common than you can imagine, corporations might also pay for vacations or leases on residences for officers. This is a common type of fraudulent conveyance lawsuit since many business owners don't distinguish between business funds and personal funds. Or, in the case of larger firms, these payments might be part of officer or management compensation. It only becomes a problem, really, when the company becomes insolvent and files a bankruptcy. It can be very dismaying for the entity being sued in such a situation. For example, the owner of a vacation rental property, since most people don't care or even notice the source of the money. They don't realize that it's coming from the company. Of course, they don't realize the company's insolvent. And of course, they're not predicting a bankruptcy and a trustee suing them for a fraudulent conveyance. This is almost always a constructive fraudulent conveyance type of action. So it is usually not done with fraudulent or bad intent by either the business or the recipient. The challenge for the defendant is typically showing how a vacation rental or some other benefit to an individual officer, for example, might benefit the company as a whole. There's another kind of fraudulent conveyance action which I think to be totally outrageous and basically a loophole in the current law. The scam works like this. There are two corporate affiliates, Company A and Company B. You ship product to Company A, but you're paid by Company B. Both affiliates then file for bankruptcy and a trustee representing Company B sues you for a fraudulent conveyance. The trustee makes the argument that Company B, one of the affiliates, paid you, but Company B didn't receive anything because you transferred property to Company A. This is basically a ridiculous argument since they're two affiliates, but the argument and these lawsuits happen all the time. There are many defenses to this scenario, but this is actually a very common kind of fraudulent conveyance lawsuit. In this kind of fraudulent conveyance case, trustee sues the manager of a company that later went bankrupt. The allegation, which I don't think is very fair most of the time, is typically that payments to the manager were not reasonably equivalent to the manager's services to the company. Why? because the company went bankrupt. The argument is basically that the manager was so incompetent that this incompetency caused the bankruptcy, and his services were worthless, so his pay must be returned. There are a lot of defenses, again, to this kind of lawsuit, but I'll go into that in another video. Leveraged buyouts is another kind of fraudulent, I would say a category of fraudulent conveyance lawsuits. It's a very complicated type of case. A very simple explanation is the following hypothetical. I buy Acme by getting a bank loan secured by all the assets of Acme. After Acme goes bankrupt, there are no unencumbered assets to pay creditors. A bankruptcy trustee argues that encumbering assets of an insolvent company to increase an equity stake in the company or create an equity stake in the company provides no value to the company. I'll go into this in another video as well. In this kind of fraudulent conveyance case, a manager makes bad deals either out of desperation because the company's in financial trouble or just incompetence. For example, a manager sells assets for quick cash at, let's say, 50% of market value. This is typically a constructive fraudulent conveyance. There's no misrepresentation involved, and the manager simply was trying to raise cash as fast as possible, but creditors end up getting a bad deal if the company goes bankrupt. In sum, there are a lot of kinds of fraudulent conveyance cases. I hope this video has answered to some degree some of the questions of what a fraudulent conveyance lawsuit is all about. Other videos to follow will go into more depth with respect to the trustee's burden of proof and defendant's burden of proof and available defenses.